to support and encourage locals who are thinking about a career in the law. It does this by organizing several weeks of intensive classes that are designed to simulate the first few years of law school. This requires flying out professors from the mainland to teach these classes. And in order to give the broader community, not just the students, a chance to learn about the law and interact with professors, we have also organized this Law in the Community lecture series. Tonight's lecture is the third of four lectures. The fourth and final lecture will be this Thursday at noon at the Guma Justicia in Suzuki. Before we begin, just two quick things. First of all, I know it's common sense, but please silence your cell phones. Last time someone's cell phone was ringing, it was a little annoying, so let's hope that doesn't happen again. The second thing, the pre-law program and the Law in the Community lecture series has been generally supported by the Northern Marianas Humanities Council. We thank the council for their support. At the very end of the program, I will be handing out some short surveys. Please take a minute and fill them out. Now, without further ado, our speaker tonight has come a long way, come home from Saipan. She's come all the way from New Jersey, where she served as the interim dean of Rutgers Law School. Please give a warm welcome to Rose Cuison-Villazor.
Thank you so much, Justice. Can you hear me okay?
Yeah.
Thank you so much for being here tonight. I'm so excited to speak with many of you about an issue that has drawn quite a lot of attention recently. And while the topic focuses on citizenship in American Samoa, my hope is to be able to engage with you on how these cases I'll be talking about, both historically, but also currently, how they, what their implications are for the Mariana Islands. And so to begin, here's just a brief outline of what I will be talking about tonight. First, I'll give a brief overview of how citizenship is acquired, including here in the U.S. territory, one of the U.S. territories. Second, I'll discuss the Insular cases, and some of you might be familiar with it, having written about it in law school. Also studied it in law school, perhaps, or since then. And certainly my students who are here, you had to read the Insular cases in class. And so for those of you who are unfamiliar with it, my hope is to just provide a brief background on the Insular cases. And then I'll talk about some of the efforts to overrule the Insular cases and some of the underlying reasons why that might be the case. And finally, I'll talk about what the implications are for the CNMI. What would a post-Insular cases America look like for all of us? And so to begin, who can tell me? So one of the things in law school, as many of you know, is that there are some engagement with students. Who can tell me what are the ways in which one can acquire U.S. citizenship? All right, Mr. Mafnas.
Born in the U.S. or
All right. Okay, good. So one born in the U.S. in the U.S. territories or in a U.S. state. What else? How else? Yes, Ms. Gao.
Naturalization.
Naturalization. Great. Okay, so birth or naturalization, two different ways, right, of acquiring U.S. citizenship, either by being born, as you can see, there's a baby picture there, or by naturalization. Naturalization is governed by 8 U.S.C. 1427. Those of you who are immigration lawyers in the room, you're quite familiar with this. Tonight's talk is not about naturalization. Instead, we'll be talking about birthright citizenship. There is a natural correlation between the two, in that citizenship overall, once one becomes a U.S. citizen, then that citizenship comes with a host of different rights and privileges. Right? But tonight's talk is focusing on how one acquires citizenship by birth. And so the first, historically, is through the common law. There are primarily two ways, two methods of acquiring citizenship as recognized by the common law. One is through what's called jus sanguinis, right of the blood. And that means that if your parents are U.S. citizens, then you also, the child, becomes a U.S. citizen. And the other way is right of the soil. And that literally means if you're born on a U.S. land, and I'll say a little bit more about that, but technically if you're born in the U.S., the United States, one of the 50 states, or the District of Columbia, or a U.S. territory, you acquire U.S. citizenship, right? So under the common law. It's important for us to recognize that the common law was not always applied equally. In fact, as applied to African Americans, the Supreme Court said in Dred Scott versus Stanford that they were not U.S. citizens at all at birth, despite the fact that it has long been held under the common law that if you're born on the in the soil, right, U.S. soil, one acquires U.S. citizenship. So in Dred Scott, the Supreme Court said that Dred Scott was not a citizen. As a result, he could not go to federal court and sue for his freedom. There was no diversity of jurisdiction. And so then, a few years later, Congress, the United States, adopted the 14th Amendment, which included Section 1, Clause 1, which says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. All right, so now we've got the 14th Amendment that essentially codified the common law of use solely. In 1898, the Supreme Court was faced with the question of how to interpret the 14th Amendment. And specifically, the question was whether a Chinese man, Wong Kim Ark, who was born in California and whose parents were Chinese immigrants, residents of San Francisco, but they were not U.S. citizens, right? They were also not diplomats, and there's an important point to be made there. So the question was whether Wong Kim Ark was a citizen of the United States because he was born in California. Mr. Wong Kim Ark actually left the United States twice. First, when he was 17 years old, he went to China to visit his parents, who had returned to China after having been a residents of the United States for about 20 years. He goes to China when he was 17 to visit his parents. He comes back, he's allowed in. Next time, a few years later, he goes back to China to visit them again, and then he returns in a year. This time, he was excluded from the border. Recall the time, this was around the 1890s. During this time, there was a Chinese exclusion case, or the Chinese Exclusion Act. Chinese were banned it was the first race-based ban that was passed by Congress. And so Chinese were not allowed to enter the United States. And so immigration officers said, wait, you're Chinese. You're not allowed to enter here. But Wong Kim Ark argued that he's a U.S. citizen based on his birth in California. And so he challenged his exclusion. The case goes all the way up to the U.S. Supreme Court. And the court said that yes, under the 14th Amendment, Mr. Ark is a U.S. citizen at birth by virtue of the Citizenship Clause. Okay. It's also important, though, to highlight that there are exceptions to the 14th Amendment. A critical exception here is what says, not subject to the jurisdiction thereof. Here it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. So who is not subject to the jurisdiction of the United States? Well, among those are children whose parents are diplomats. Why might that be the case? That if you're a child of diplomats, then you are considered to be not subject to the jurisdiction thereof, even though you were born on U.S. soil. What could be the argument that you're not subject to the jurisdiction thereof? Yes, Mr. Guerrero.
Perhaps because of the diplomatic immunity sometimes afforded to diplomats, particularly with the specific plot of soil?
That's right, right? A diplomat means that they're not subject to the United States. And as a result, then if you're a diplomat and your child is born in New York, that child does not acquire birthright citizenship, right? A second exception here, under the not subject to the jurisdiction thereof, are members of federally recognized tribes. If one is born in a tribe that is federally recognized, that person is not a U.S. citizen under the 14th Amendment. And then the other exception here, and this is what we'll talk about this a little bit more later. If you're not born in the United States, then you do not acquire birthright citizenship under the Citizenship Clause. There are statutes that allow one to be recognized as a citizen, but not under the Citizenship Clause. Okay, so we talked about the common law, and there were two that I mentioned, jus sanguinis and jus soli. The 14th Amendment subsequently codified that into the U.S. Constitution. And then remember the exceptions. As I mentioned, there are statutes. And here I'll introduce us to some of the statutes that apply to the U.S. territories. Okay, so next question. Those of you who are born here in the CNMI, raise your hand if you were born in the CNMI. Okay, and I'll say, I won't give a date. Some of you are probably born before 1986. Some of you are born after, right? The point here is just whether you're born here. Are you a U.S. citizen under the Citizenship Clause?
Yes.
You're not. Why?
Because it was when we became a territory in 1978 when we signed the covenant, that gave us citizenship.
Yes, and
Okay.
it became effective when? Who can tell me the magic year when you became U.S. citizens?
November 4.
Yeah, don't we celebrate it here?
Yeah,
Is it
Citizenship Day.
Covenant Day or something?
November 4. Citizenship Day. I think it's
Citizenship Day, yeah. 1986, good. Okay, great, Ms. Gao. Okay, so birthright citizenship in the U.S. territories. Here's the list of all the various U.S. Territories. Acquired after the 1898 Spanish-American War were the Philippines, Puerto Rico, and Guam. And then after that, American Samoa acquired or became part of the United States, depending on who you're talking to. American Samoa became part of the United States in 1900, and then the Virgin Islands in 1917, the CNMI in 1975. When did U.S. citizenship get extended to these territories? The Philippines was never extended, and we'll talk about why that's the case. Puerto Rico, not until 1917. Guam, 1950, through their Organic Act. Right? American Samoa also never had a law extended granting them U.S. citizenship. And then the Virgin Islands came later. Their citizenship came in 1927, and then the CNMI in 1986. There's a notation here, but we're not going to go into detail about it, but there was a litigation called Sabangan versus Powell that recognized citizenship for some people who were born in the Marianas before 1986. And the dates there are January 9, 1978 to November 4, 1986. They are considered to be U.S. citizens even though they were born before 1986 and their parents were not TTPI residents. Right, so I'm happy to talk about that some more during the Q&A. It's not germane specifically to the issue for tonight. But here are the statutes that provide citizenship for people in the U.S. territories. Right? So if one is born in a U.S. territory, then the citizenship is grounded not in the Citizenship Clause, but by statute. So I'll pause here. It doesn't matter from your perspective that citizenship is not based in the U.S. Constitution, but rather based in statutes. What difference does it make if one is a U.S. citizen no matter what? Right, at birth, whether it's through the 14th Amendment or through congressional statute.
They take it away.
Yes, okay. So in theory, right, what Congress giveth, Congress can take away. By contrast, the U.S. Constitution, if a right is granted through the U.S. Constitution, it's either through the interpretation by the Supreme Court, right, or by congressional amendment. And so theoretically, it hasn't happened in a long time. The citizenship can be taken away by, well, it hasn't happened, that Congress has given citizenship and then taken it away. That's Mr. Buffett, that's the argument. Okay, so you saw here that before citizenship was acquired, people in the U.S. territories had U.S. nationality, right? The question then is, what is a U.S. national, or what does it mean to be a U.S. national and not a U.S. citizen? As you can see in this chart, Filipinos and American Samoans are the only ones that didn't ultimately have citizenship extended to them by Congress. Okay, so there are two key Supreme Court cases that provided some definition of what U.S. nationality means. First is the Gonzalez versus Williams case, and here really the question was whether this Puerto Rican woman who was entering in New York, whether she can be excluded from the border. And ultimately the court said no, cannot be excluded, but she's not necessarily, because she's not an alien, an alien with quotes, right? So she's not a non-citizen, but the court didn't say whether she is a U.S. citizen, so left that open. That was in 1904. Then in 1925, there was a case that involved citizens of the Philippines, and there the Supreme Court said that Filipinos who were then at the time, the Philippines was part of the United States as a U.S. territory. They were neither citizens nor non-citizens. That's what U.S. nationality meant, right? It's in this in-between state, it's an interstitial citizenship, that's what I call it, in between the space between citizen and non-citizen. That's what U.S. nationals fall within those interstices. It's actually recognized by statute. Under 8 U.S.C. 1408, a person born in an outlying possession of the United States on or after the date of formal acquisition of such possession is a national but not a citizen of the United States. So unless Congress passes a separate statute extending citizenship, then if one is born in any of these U.S. possessions, that person acquires U.S. nationality. What does that mean then? It's important to understand that these, a lot of the cases that dealt with U.S. nationality are a part of the American Empire. This is a political cartoon that was created during this era, the early 1900s. Notice how Philippines, Hawaii, Puerto Rico, Cuba were all viewed as wards of Uncle Sam, students of Uncle Sam. This obviously was a critique of the American Empire in the 1900s. I use it here just to highlight some of the connections among the other territories that were acquired. Either those, Hawaii, which was a territory that ultimately became a state, and also Cuba, right, a place in which we have, the United States had strong military interests. And notice too how a representation of a Chinese immigrant is at the door, which means that he was not being allowed in. And then an American Indian, a member of an American Indian tribe is at the back with reading upside down. And so again, this is just part of a framing of what was going on during this time, during the American Empire, and that was influencing how the U.S. Supreme Court and other courts were addressing questions of constitutional law in the U.S. territories. Okay, so what difference does it make that someone is a U.S. citizen and that someone's a U.S. national? Well, here's a chart to give us some brief explanation. Right, as both U.S. citizens and U.S. nationals have the right to enter and remain in the United States, they can never be deported. So if an American Samoan moves to the United States and commits a crime, let's just say, that person cannot be deported because American Samoa is part of the United States. Right? When the Philippines was a U.S. territory, same thing. Filipinos could not be deported to the Philippines because same idea, the Philippines were part of the United States. Right to vote is one, and then there are these different rights of citizenship. Right to vote, right to serve on the jury, right to petition family members to immigrate to the United States, right to work or apply for federal jobs. Those are limited to U.S. citizens, with some exceptions if it's allowed by a particular employer, for example, then that person could apply for federal employment. Those are rare. So U.S. nationals are prohibited from voting, from participating on the jury, petitioning family members, applying for certain federal jobs, including law enforcement jobs, right? And so, yes,
But petitioning family members,
they can as U.S. nationals.
yes, I've just done that.
Okay, so Mr. Mailman, thank you. That's helpful for us to think about. But one of the current lawsuits right now, that's by American Samoans, they've argued that USCIS does not recognize their ability to petition.
Those Americans petitioning family members.
Okay, and it's been approved?
Oh, yeah.
That's great. I mean, I think that might be the first that's certainly the first that I'm hearing about this, because the live case right now, among the issues that they've raised is they're unable to petition for the family members because they are not U.S. citizens. Right? U.S. citizenship comes with a host of rights and privileges, including the ability to vote and ability to petition family members for family unification. Yes, Chief Judge.
Here's a comment if who's this client was an American Samoan who was naturalized, because I'm naturalized American Samoan. So.
Naturalized after they were approved.
Oh, yeah.
And I looked up laws currently that U.S. nationals can sponsor family members with green cards if the family members otherwise qualified. They don't get, what they don't get, and I'm sorry for interrupting, is that if you're a U.S. citizen and you have a family member who has, for example, stayed out of status, but the application is otherwise successful, it's forgiven. It's not the same case for the immediate relative national. They're treated exactly as if they were green card.
Oh, interesting. I'm going to have to look that up, because I think that the current litigants in the Samoan case would really be interested to hear about this case that you just successfully filed. Because for the most part, the ability to petition family members resides in the right of citizenship, not in the right of U.S. nationality. And so why is that the case? Why is it that there are differences between rights for U.S. nationals versus rights for U.S. citizens? Here is a good segue for us to talk about the insular cases. Right, there are a host of insular cases. Some scholars say that it's only the cases in the early 1900s, 1901. Others it's expanded to 1922, and even others have expanded the scope of the insular cases to beyond 1922. For lawyers here, I just thought I'd highlight for you some of these the citations for the insular cases. The key Supreme Court case is Downs versus Bidwell. And here, I highlighted included some quotes for you from the case itself that shows why the insular cases back then and now are quite problematic, right, from a race-based perspective. Here I'll read just parts of the quote. According to the Supreme Court, those possessions are, referring to the U.S. territories, those possessions are inhabited by alien races differing from us in religion, customs, laws, methods of taxation and modes of thought, the administration of government and justice according to Anglo-Saxon principles may for a time be impossible. The court continues, we are therefore of the opinion that the island of Puerto Rico is a territory appurtenant and belonging to the United States, but not part of the United States. And so here's the key phrasing of Puerto Rico and other U.S. territories as foreign, but in a domestic sense, right? So they're domestic in that they are part of the United States, but they're foreign because they are different racially, culturally, and ways of life. And as a result of those differences, the court decides to not extend all constitutional rights to Puerto Rico and all the other U.S. territories. Here in Downs versus Bidwell, the court further talks about how citizens of the United States discovered this unknown land, people with uncivilized race, yet rich in soil, and valuable to the United States for commercial and strategic reasons, right? And the court continues that the people in Puerto Rico were inhabited by people who were utterly unfit for American citizenship.
Are there any typos in these things that you?
No, I'm afraid not, sir. These are, and this is only one. There are these other cases here are filled with other quotes that that describe the people of the territories of, at the time, Puerto Rico, Philippines, Hawaii, and those are the three main places that were addressed in these cases. Okay, here's another one later in time, 1922. And in this case, by this time, by 1922, the Supreme Court had already established the proposition that because people in the territories are different, then the Constitution does not follow the flag. Right? By this time, by 1922, the court has said that it's well established that the entire Constitution applies to United States territory of its own force only if that territory is incorporated. Incorporated essentially means, as the Supreme Court explained, is that if they are on their way to becoming states, so subject to statehood, right? That means that the other territories that we're talking about by this time, the 1920s, including Puerto Rico, the biggest, well, Philippines was the biggest at this time, they were not subject. Puerto Rico and the Philippines were not subject, were not on their way to becoming states, and so they were unincorporated. Because they are unincorporated, then only fundamental rights would apply in the territory. Okay, I'm going to pause here. Are there any questions so far about the framing of the Insular cases? Why the courts used the Insular cases and how they applied in the territories? Okay, all right. So now I want to bring us back to the question of citizenship. Right? Recall that I said, I highlighted the Wong Kim Ark case, that under the 14th Amendment, the Supreme Court said that if you're born in the United States, subject to the jurisdiction thereof, you're a U.S. citizen. Right? So then the question becomes, well, what about being born in a U.S. territory? Why is it that it had to be done by statute? In the case of Rabban versus INS, a case decided by the Ninth Circuit in 1994, the Supreme Court addressed that, the Ninth Circuit addressed that question and said that relying on the Insular cases, the term United States, as used in the Constitution, is limited only to the states of the Union. And so, as a result of that, the court, the Ninth Circuit said that it would not be correct to extend citizenship to persons living in the United States territories simply because they were subject to the jurisdiction thereof. So, in other words, the Philippines, during this time when Mr. Rabban was born, he was born a U.S. national, the Philippines, as a country, was subject to the jurisdiction of the United States. But because it was not part of the United States, because of the Insular cases, the court said that birth in the U.S. territory did not lead to U.S. citizenship. Yes, Mr. Guerrero.
Does that mean that the court implicitly implied that citizenship is not a fundamental right contained in the Constitution? Because in your previous slide, you said only fundamental constitutional rights apply in the territory. So by principle, citizenship is not fundamental?
Yeah, not yet. No. So instead of engaging in the question of whether citizenship is a fundamental right and so therefore would apply, instead, the court in the Rabban case only focused on the subject to the jurisdiction thereof component of the 14th Amendment and said that it does not apply. Right? Subsequent cases did examine whether citizenship is fundamental such that it ought to be applicable. But that's not this case. And we'll get there in a few slides. Rabban was not the only case. There were many other cases. Here's a list of them. Okay, so the Ninth Circuit, the Second, the Third, and then there's another Ninth Circuit there. And then also the DC Circuit, the District Court, the number one up to the DC Circuit. As I'll talk about soon, the 10th Circuit also addressed the question, but it's not involving Filipinos, but instead American Samoans, right? But at this time, we understand that at least with respect to Filipinos who were born in the Philippines and were U.S. nationals, they did not acquire U.S. citizenship under the citizenship clause, right? It was, if any kind of claim to citizenship, if for them to be successful, it had to be based on a statute extending citizenship to them, unless they're able to naturalize through some other means. Okay, so now we fast forward to American Samoans and U.S. nationality. Today, American Samoans are the only U.S. nationals. They have a U.S. passport, but when you open it up, it says that the bearer is a United States national and not a United States citizen. So how might how might American Samoans acquire U.S. citizenship? Yes.
Naturalization.
Okay, right. So they can naturalize. Can they naturalize in American Samoa? They have to leave. They have to move from American Samoa. They need to move to one of the 50 states and then apply for naturalization. Naturalization costs, actually, Mr. Mailman, tell me, what is the fee for naturalization these days?
$725 including biometrics.
Okay, all right, so over
No,
seven.
that's not the attorney's fee.
Come on, pro bono, right? All right. There are naturalization fees. There's a cost of moving, right, to one of the states, looking for a job there in order to support yourself and your family. Leaving family behind in American Samoa if you want to. Those are some of the things that one has to do in order to apply for, to become a citizen if you're from American Samoa and you want U.S. citizenship.
Mr. Rhodes?
Yes. Yes, Chief
You
Judge.
mentioned that going to a state that we naturalize them here. Is it because they don't have a district court in American Samoa? That
That's
they have to
right.
leave?
Yeah, so under this, they had to, I think that makes sense. There's no place, but I mean, they can go to USCIS and apply, but they would have to go outside. Yes. And this is such a cost to them also from a military perspective. One of the arguments that have been made by some American Samoans is that many people from American Samoa join the military, and somehow they don't have the benefit of citizenship, right? They have to, they're U.S. nationals, and remember the chart. If you're a U.S. national, you can't vote, can't serve on a jury, can't apply for certain jobs. For those who are going to college, it means that they can't apply for some federal loans, or they can't qualify for Pell Grants, for example, because those are limited to U.S. citizens.
Professor,
Yes, sir.
you mentioned the military. Can American Samoans become officers of the military?
Oh, sir, I don't know, actually. Does an officer have to be a U.S. citizen? Then, I mean, I'm not, so it's not my area, and I'm reluctant.
I'm just asking. Because
Yeah.
you mentioned, because there is quite a number of them in the military services.
So if the requirement is U.S. citizenship, then they would have to, for anything, whether it's for a job, law enforcement job, or in the military, then one would need to satisfy that requirement, right, and apply for citizenship.
I don't know if this still holds across the board, but the dividing line between who could hold what job had to do with the determination that the job was or was not a policy implementing job, or a policy-making job. So,
And so that might go to the exceptions,
and
right?
sometimes they were very strange determinations. Many years ago, I was a driver's license examiner in California. One of the people in my cohort coming in was a stateless guy who was told that only that year, due to a court case, could he have this policy-related job, driver's licenses.
I suppose, I mean, if the policy requires citizenship because of decisions that have to be made, I can understand the reasoning behind that versus some requirement that, or a job that doesn't have the responsibility of policy making. Okay, so here, bringing us back to the American Samoans and U.S. nationality, the most recent case to challenge the lack of citizenship for American Samoans is the Fitzsimonu versus United States case. This was filed in Utah. There were 3 Utah residents who were born in American Samoa and had lived in, became residents of Utah, and they wanted recognition to as citizens by virtue of the citizenship clause, instead of having to apply for citizenship through naturalization. And here, the district court relied on Wonkim Art case and said that yes, the citizenship clause applies to in American Samoa, and therefore these residents were citizens under the 14th Amendment of the Citizenship Clause. That was a victory, right? Prior to this case, there was another one, the Tuawa case, that led to that it resulted in both the district court and the D.C. Circuit disagreeing with individuals who claim that they are U.S. citizens. So this district court was the first time that there was recognition at all in any time in all the cases in which a citizenship claim was based on birth in the U.S. territory under the Citizenship Clause. This was the very first one. I do want to point out that the American Samoan government and the time Congresswoman Amada, they moved to intervene in the case. Here, this is a consistent position that the government of American Samoa has taken even before in the first case, in the Tuawa case. And in this, even to this day, the American Samoan government have intervened and have argued that citizenship should not be extended by the court. Instead, they've said if citizenship is to be extended to the United States, it should be done by Congress, not by what they call judicial fiat. If you read the case of the citations there are also other arguments as to why citizenship should not be applicable in American Samoa. And again, this is the perspective of the American Samoan government. They're saying that because of the American Samoan way of life, the life of American Samoa, they are concerned about citizenship. If they were to become U.S. citizens, then they might lose some of their cultural traditions in both in land ownership, but also in the different types of titles that they give to their chiefs, the Matai system. And so underlying their concerns here, the American Samoan government, is they want the ability to have to negotiate with the United States what citizenship would mean for them, instead of going to a district court and then a circuit level and then the U.S. Supreme Court, having to decide for them whether they should be considered U.S. citizens under the U.S. Constitution. So this is also another good time to pause and ask whether there are people here who know, of course, the history of how the CNMI came to be. What are your thoughts about the argument that citizenship should not be done through the U.S. Constitution, but instead through congressional statute, through some kind of an agreement? Does that make sense? Even if you disagree with it, does it make sense to you that that would be the point that they're making? That there should be some kind of a political negotiation with Congress?
The covenant is an act of Congress, right?
Yeah.
So that's the founding document for the CNMI. So that document exists as evidence of that.
And in the covenant, as you know, I'll kind of fast forward a little bit. The covenant included the discussions about land alienation restrictions, right? That later became part of the CNMI Constitution. And so there was a case that challenged what's Article 12, and then we'll tie that with what's going on here. But yes, ultimately, for some, those in American Samoa, for them, citizenship should be decided by the people instead of by through political negotiation, instead of having to go to going through a case and having a court make that decision for them.
Yeah, Professor,
I would disagree a little bit with the statement that the covenant is an act of Congress. It's a negotiated agreement approved by Congress. I think the distinction is quite important. That's my first point. My second point is that the covenant itself included the option to select being a national rather than a citizen if the individual wished. I believe that not a single person in the Northern Marianas chose to be a national rather than a citizen, so everyone became citizens. But that option was included as part of that. So I think it's limited applicability to the unique situation of American Samoa where they see a potential cultural conflict with citizenship. I don't think anyone in this might ever perceive anything like that.
As in the connection between citizenship itself, formal citizenship, and cultural traditions.
Right. We had Article 12, which was actually an initiative by the U.S. side of the negotiations, but then became considered to be an important part of those unique provisions of the government that have been protected, so to speak, by the Insular cases when they were challenged in court. And some things weren't protected. So.
And we'll talk about the Wobble case and the Insular cases. But as to your point, I'm not going to quibble in a room full of experts on the covenant and whether it was congressional or not. But in 1980, when the covenant became effective in 1975, there was an act of Congress. It had to be approved by Congress. It had to be signed by the president, right? But yes, I think the point here is well taken. There was a political agreement. There was negotiations for the different provisions of the covenant. We have in the archives here all the section by section analysis of the covenant and as well as the legislative history of the covenant and what the people here have negotiated with the United States. We know that at the district court level, the American Samoan government intervened. They were allowed to intervene, and then the case goes up to the 10th Circuit, and here the 10th Circuit recognizes that there are two lines of precedent. Either the Wong Kim Ark case, 14th Amendment, citizenship clause applies, or the Insular cases, right? And here, the court recognizes that the Insular cases are indeed controversial. They've been criticized for amounting to a license for further imperial expansion and being based in a racist ideology. There were no mistakes earlier, as I mentioned earlier. So that's quite clear just by reading the text of the cases. The court also recognizes that the purpose of the Insular cases, to us today, the reasoning is now questionable. There are concerns about native inhabitants of the unincorporated territories that were simply unfit for American constitutional regime. And those are problematic today for us. Problematic then, certainly problematic for us today to hear and to read. Right? So the court recognizes the problems of the Insular cases. Yet the court also emphasized that the Supreme Court continues to use the Insular cases as a framework for deciding constitutional applicability. And as a rule of law, we must follow what the U.S. Supreme Court has said. Right? And so as a result, the 10th Circuit said, notwithstanding its beginnings, the Insular cases provides a flexible framework. And the court says it has been repurposed to preserve the dignity and autonomy of the people of America's overseas territories. So here's the repurposing of the Insular cases that is coming into play, not only in this Cuison-Villazor case, but also in the Tulao Law case that I mentioned earlier. There have also been new legal scholarship talking about the revitalization, repurposing, the rehabilitation of the Insular cases, to cast aside their racist ideology and instead think about how they might be used to preserve autonomy and self-determination. And guess which cases are being used primarily to make that case, to make those claims? It's the cases in the CNMI. In particular, Wobble is one of the cases that many of these law review articles have cited as the basis for repurposing the Insular cases because of the way that the Insular cases have been used to uphold Article 12. So more on that in a minute. And lastly, the court says that there are grave misgivings. The court had grave misgivings about imposing citizenship on the American people, particularly when they've said in court that they don't want it, right? The people said they don't want it, even though these individual American Samoans in the States have said we want to be recognized as citizens. So then one question becomes, we know that American Samoan government have said we don't want citizenship. How have the other territories responded? There was amicus briefs filed by Guam, NMI, Puerto Rico, U.S. Virgin Islands, and they've all argued, along with the ACLU and many other scholars and activists, to say that the Insular cases should be overruled, right? And with respect to the citizenship issue, they've pointed out that U.S. citizenship is compatible with the preservation of each territory's distinctive cultural heritage, right? So there's no disconnect at all between citizenship and culture, according to this amicus brief. And in full disclosure, I have submitted, I have joined amicus briefs for different law professors, constitutional law professors. I've signed on to those briefs. I was also part of a brief from legal historians arguing for the overruling of the Insular cases. But I've also always said with a caveat, and this is what I testified before Congress last year, that one thing that we need to acknowledge is how the Insular cases, as racist as they are, have led to the preservation of Article 12 in the CNMI. And there ought to be a discussion about that. That should be included, in my view, as part of the analysis as to whether to overrule the Insular cases. Okay, so I've been speaking for 47 minutes now, and I'd like to make sure that we have some time. I'd like to end here by talking about post-Insular cases, America, implications for the CNMI.
For the entities in some of those jurisdictions who filed that this, where it says the CNMI and Guam.
Oh, these are I have to look back proportionally.
Or the individuals.
No, these are congressmen, the representatives of these territories. But it wasn't only them, there were also other individuals who filed amicus briefs in support of overruling.
I think it was the Attorney General for the CNMI.
Well, this is a separate one too. I mean, there are a number of different, many amicus briefs filed and in support of the individual American Samoans.
In the case of this particular amicus brief for the CNMI, it was Representative Sheila Babauta in the CNMI House.
Okay, thank you.
Professor,
Sir.
where's the best place to find this, what you just stated, that Insular cases are somehow supported or part of the well? Where can we go there?
You can go to, I can send you the link to this website, Equality Now, that lists many different briefs and legal scholarship that talk about that point, but also counter arguments. Right? There are just to present both sides of the issues. That particular website, and there will be links to other websites too, where you can find those arguments.
Or maybe just email it to the bar. Maybe our executive director can share.
Yeah, I'd be happy to.
Thank you. Thank you.
Okay, so post-Insular cases, America implications for the CNMI. Article 12, I'm going to go through some of these slides quickly because we're familiar with them. Article 12 limits land ownership or possession of land to persons of Northern Marianas descent. I know I'm glossing over technicalities here. I wanted to point out that NMD refers to people as citizen or national of the United States who originally at least 1/4 Northern Marianas Chamorro, Northern Marianas Carolinian blood, or a combination thereof, or if a person is adopted, right, by before the age of 18. And then the purpose of for purposes of determining NMD, a person shall be full-blooded at Northern Marianas Chamorro or Carolinian if that person was born or domiciled in the NMI by 1950 and was a citizen of the TTPI before the termination of the trusteeship agreement. It was subsequently amended so that any person who has some degree of Northern Marianas Chamorro or Carolinian blood or combination thereof. If they have some degree of Northern Marianas Chamorro, Northern Marianas Carolinian blood, then they are persons of NMD. Okay, so Wobble versus Villacrucis. I assigned this case to my students. We had 2 days talking about it. It was a challenge to Article 12, as many in the room are aware. And here the Ninth Circuit views the insular cases. The court says that interposing constitutional provision of equal protection law would both be impractical and anomalous in this setting. Absent the alienation restriction, the political union would not have been possible. It also would have hampered the United States' interests and ability to form political alliances. And for the NMI people, the equalization of access would be a hollow victory if it led to the loss of their land, their cultural and social identity, and the benefits of United States sovereignty. So these are the specific reasons why, according to the Ninth Circuit, applying to insular cases, Article 12 should be upheld, right? And it continues to, so the challenge did not, was unsuccessful. Article 12 remains constitutional. So then, if the insular cases are to be overruled, the question becomes, will Article 12 survive equal protection challenge? Right? The court would have to analyze the 14th Amendment's equal protection clause, which says that no state shall deny to any person within its jurisdiction the equal protection of the laws. And a court would have to look into looking at different levels of scrutiny, depending on whether Article 12 NMD is considered to be, if it's not a racial category, then the application, the proper level of review will be rational basis. If it's a racial category, then the level to be used of scrutiny would be strict scrutiny, right? Which is the strict scrutiny is applied to any kinds of discrimination or distinctions on the basis of race, color, or national origin. And so here we've got two different ways of thinking about it and how a court might look at a challenge, any future challenge to Article 12, assuming the insular cases are overruled, which we don't know if that's ever going to happen. But theoretically, if NMD is considered to be a racial category, then strict scrutiny, as I said, will be the level of review. And in that case, Rice versus Cayetano will be the operating, will be the framework. Rice versus Cayetano and the Davis case are unique, though, in that those are 15th Amendment cases, right? So arguably, those are just different, and that makes sense that it would be the 15th Amendment is an important amendment that has a long history of jurisprudence. If NMD, that category, is a political category, then Morton Moncari applies, which means that a court would use rational basis and most likely would be upheld because of the importance of recognizing that there are certain political categories that are acknowledged as belong within equal protection jurisprudence. All right, so I will end there, but I'd like to highlight some, if you're interested in reading law review articles that are quite lengthy, and here I want to acknowledge some of my former research assistants who helped me in some of these writings, like Jose Matnes and Jim Smith. They helped to help me with some of this research that I did. And these are 4 law review articles I wrote, not only looking at Article 12, but also just in general, the insular cases. I'm happy to send you links to them if you're interested in reading some more. With that, I'd like to open it up for any additional questions or comments about any of the slides that I presented.
So, do you think cert will be granted?
Well, what's interesting is that Justice Gorsuch, in a recent Puerto Rico case, he said that it's time to overrule the insular cases. And there's a strong movement to overrule the insular cases. I don't think it'll be granted, though. I would be surprised if the court ends up hearing it. But if it does, and the Insular cases are overruled, I think it's about time, right? There's no reason why the Insular cases should continue to this day. I also don't think it's the end of Article 12. I think there are strong reasons historically, culturally, to support Article 12 even under the equal protection framework of race or political category. I'm more of the political category camp. I think one can make a strong case that at least the original covenant, that it was a political category. As I said to my students today, here, if NMD is considered to be a racial category, it'll be really difficult, in my personal opinion, for that to be for it to survive, given the history, given the long line of cases that a court must follow. But political category might be one way to uphold Article 12, and but it remains to be seen. It depends really on whether the Insular cases will be overruled.
Professor, can you come across the case of the new racist TPI?
No, I'm not familiar with that case.
I recommend.
Okay, what was the case about?
It's about the state sirens for getting more money than it was just people from a little bit closer to home.
Okay.
We want the people.
Yeah, I'd love to get the citation so I can look it up. Okay. Thank you. Yes, sir.
So I came from the bygone era, 1978 when we voted. The education there was, we understand we're a minority. I'm from the Caribbean, or the side. But we understand we are minorities, and when we join the union with the United States, we're gonna not count them. We're not. So I think that big sell from the political side was, we're gonna try to put in something to protect the islands. And that was the Article 12 that came about, that negotiation. Because Mr. Moore and the Carolyn understood that if we have a union with the United States, we're just numbers.
And I think the Wobble case said that the covenant would not have continued. It wouldn't have happened. The Commonwealth would not have happened if Article 12 or land alienation restriction was not included. So although that language was part of the Insular cases, I think it can still be used within a straight up equal protection analysis.
No one seemed to be talking about the makeup of the CNMI Senate and how this would affect that as well. That seems pretty foundational to me. If these laws or if these cases are decided in that manner, but that seems to really attack.
There was a case exactly.
That was one of my cases.
Yes.
Yeah, what was the name of the case citation? Or the title?
It was rape and beating,
right.
but in the Supreme Court it was Orders versus
Rape and Peace of Lawn, wasn't it?
Yeah, Orders versus Sublime. Yeah, rape and Peace of Law.
Yeah.
It was a direct appeal to the U.S. Supreme Court. It was a
Right,
three-judge
because
court case.
It's about legislature, the makeup of the legislature.
Yeah. These courts were judged and decided that it was law.
You know, from my perspective, when I do these talks, I normally don't hear from the lawyers or or other litigants involved. So it's really it's such an honor to be up here to be able to talk about them. Yes.
Hi, Professor. I'm intrigued with the U.S. national space, and I'm wondering if you could share a little bit about the amicus briefs. You just passed that. But they argue that U.S. citizenship is consistent with preserving sort of the cultural heritage in these jurisdictions, but it seems to be the opposite for American Samoa. It seems that that's the argument with U.S. citizenship were to be distributed among the people in American Samoa, but it's somehow threatening the cultural heritage. What would the argument?
It's their beliefs. It's how they've had a political it's a commission to talk about it in American Samoa, and there's just this fear that citizenship will lead to the undoing of some of the protections for their cultural traditions, including land ownership, but also the chief system, the nobilities, titles of nobility, which are not allowed in the U.S. Constitution. And so in informal conversations that I've been a part of, the CNMI example is often given to say they're U.S. citizens and they get to keep their land ownership restriction. Citizenship is not the thing that you ought not be worried about it. But again, informal conversations. From a formal, at least formally, in the briefs that were filed before the courts, they said that there's just this, it's what they want to be able to be at the table and have some discussions about what citizenship means for them. Mr. White.
Why don't they? I asked the same question to Neil Wheeler.
Yeah.
And he couldn't give me an answer. Why don't the Samoans say we need to negotiate a covenant right now?
They can. I mean, Neil and I have talked about this too. I think one of the things that Neil and Equality Now, they're hoping to be able to do is go to American Samoa and encourage them to ask for a negotiation, right? They're unincorporated, and so they can. They have yet to have that kind of, to have a seat at the table. I'm not sure there's such desire, no, right now. Yes.
I keep seeing the word territory there. Is the CNMI considered a territory, a U.S. territory?
From a legal perspective, it is, but there are different gradations of territories, and the CNMI has the covenant that frames the rights and obligations and privileges of what it means to be, why it's distinguishable from, let's say, Puerto Rico or from Guam. But from a technical perspective, there are 5 U.S. territories, and what that means is Congress can do what it wants. Congress has the power under the U.S. Constitution to extend rights, to deny rights, right? But the CNMI has a covenant that governs the various responsibilities and what the relationship looks like.
Yes, and we have that covenant, right? We also have, isn't it I don't want to say supreme, so you guys might attack me, but
I won't attack you.
It's because it was negotiated within that covenant about we make our own laws. But isn't that considered as supreme than the U.S. territory?
I'm going to give the classic law professor answer, and that's it depends. It depends on what issue we're talking about. If we're talking about certain rights that are statute, I mean, we have a system of federalism. The United States still trumps states and U.S. territories, but there are certain rights that reside in the states, certain rights that reside in the CNMI by virtue of the covenant. So it depends. It depends on what we're talking about. I'm seeing more hands, and I don't remember what time. Some people haven't had lunch yet, dinner yet. And, okay, so I'm going to call in. I saw new hands. Have it, Mr. Bautista, and then Mr. Marcos.
Thank you, Villazor. I don't want to belabor this issue too much because I know that we kind of talked about this a couple years ago in the past. But then the applicability of the Second Amendment here in Samoa. I know that like what we talked about was the applicability of the Constitution as a whole as a territory. But then could you maybe shed some light on where that argument lies with the applicability of the Second Amendment, given the lack of gun right ownership, or sort of I don't want to go again into a controversial space, but then more of we don't have a history of gun violence here in the Northern Mariana Islands. Could you maybe shed some light on that?
I'm not familiar with Second Amendment issues in the CNMI. I'm actually also not, it's outside the scope of my expertise. So the way that an off-the-cuff response there, well, first question, has it been challenged? Has anyone challenged it?
Yes. I believe it was Daniel. I believe it was the Radish case. I stand corrected with all lawyers in the room. But I believe it was the Radish case.
Wasn't this your note? No, your note was on
I
something.
think there were actually two cases, and the district court rules that, the more recent federal, Supreme Court Second Amendment jurisdiction is binding on the CNMI. I personally would take a totally different position given our activist Supreme Court. Which is that the understanding of the Second Amendment at the time that the covenant was negotiated should govern. But I don't think that argument was made to Judge Monroe.
Well, how about this? It's just outside of my area of expertise, Mr.
We'll save that for another day.
Let's save that for another talk, and we'll invite someone who's an
We'll talk about spear guns.
We did have an attempt by certain parties to intervene in that case for purposes of appeal to the Ninth Circuit because the Attorney General's office declined to appeal, but the Ninth Circuit was not allowed.
All right.
Indeed.
Mr. Marcus.
I didn't write on the Second Amendment, but I questioned, you mentioned political classification for an entity. I guess in your opinion, what would be the strongest argument in support of political classification rather than race?
The history of the covenant, the history of how the Commonwealth came to be. I think there's enough legislative history to say that the people of the NMI negotiated for the terms of their citizenship, and that land alienation was an essential component of that agreement. One might say, well, it was the United States that insisted upon it, which they did, but at the same time, the people wanted it also, right? And so regardless of who asked for it first, it was, as the records show, it was an important part of the negotiation. And so within that framing, the Article 12 came about, and it started off with 1950 as a baseline, right? Someone had to be here, born or domiciled in 1950, had to be a TTPI resident, and TTPI citizen. And as a result, one can argue that this is a political category, not a racial category. There was a case, there was a Guam case. It's not in one of my articles here, but I made the claim that it can be argued to be a political category because there are people who are Chamorros and Carolinians who were not here in 1950, and they were not TTPI citizens, so they would not be they would be excluded from Article 12, right? I'm not really sure what it means now that it's been expanded to some degree of northern Chamorro Carolinian blood. But at the beginning, the founding, I think there was a strong case to be made for political categorization.
Professor, was there, in one of your slides you mentioned that the government of American Samoa and Congressman Ahana intervened in the case? Do you know if they were on the same side? And then for, I think, of course I want, my brothers and sisters in American Samoa to have the same protections that we have, but I am worried about, I guess people from Saipan or Northern Marianas moving to the States and abroad, and then essentially challenging things that would unravel protections here by courts that are very foreign. I mean, there are a lot of people in Boise, Idaho, so will a judge in Idaho unravel Article 12 or whatever else? And I guess just that idea just kind of doesn't sit well.
Now, I hear that, and there's a divide that seems to be the case with this Cuison-Villazor and the earlier case, Tuawa, in that the stateside American Samoans are the ones arguing for citizenship under the Citizenship Clause, and then American Samoans in the territory are saying, no, we don't want that, right? So then there is that, there seems to be that divide. What I've heard is that there are people in American Samoa who do want citizenship, because they don't want to have to apply for it. They already swear allegiance to the flag, right? They join the military. But what I'm hearing you saying is that what does it mean that someone can go to one of the 50 states and then challenge an issue? There are different facts here, though. Someone would have to be here in order to go before the court here to challenge Article 12. In this case, he couldn't find a job. He couldn't apply for certain jobs. So the harm for him was in Utah, right? And so the facts are different. But I hear what you're saying about the fear of someone undoing a cultural practice or tradition, and that being done by someone who has left.
I think, Professor, just very quickly, if you look to our brothers and sisters in Palau, the Marcials, the FSM, they still have their traditional governmental structures in place, albeit they're not citizens, but they act and do things just like any other American citizen, but they still have it. The courts, however, have made it very clear. If you are not voted into office by the people, you have no business talking about government or theirs. So the traditional chiefs in Palau, see. And the court did, because the Constitution of Palau says all government must be the public informed one.
And thank you for that. That's really enlightening. One thing that I'll close with this. These constitutional questions are challenging because we have the U.S. Constitution, which is the law of the land here in the CNMI also, alongside the covenant and alongside the CNMI Constitution. And so the question that I leave you with is, how do we balance the rights and obligations of citizenship? What does it mean to be part of the United States and still be able to have traditions and cultures protected by laws here that the people wanted to protect, right, through the covenant, through the CNMI Constitution. And so everything remains to be seen, depending on what happens with the Insular cases, and then what happens after that if someone were to challenge Article 12. I think I'm out of time now, and so thank you so much for. Answer questions up here if you want to come.
I'm sorry.